Rise. 55th Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good morning, you may be seated. Calling the case of People versus Jeremy Robert Tigner, file 21-6693-FC and case 18-5823-FH and file 20-6327-FC. Would counsel identify for the record, please?
Michelle resides here against People.
Please, the court, Scott Moore.
And appearing on behalf of the Clare County Circuit Court Probation Department and Michigan Department of Corrections.
Agent McConnell, Your Honor.
Good morning, all of you. Today is the date and time for the arraignment in the 2021 case. And I believe that the two probation violation cases as well. How do you want to proceed in that regard, Mr. Moore?
Thank you, Your Honor. I had indicated to the assignment clerk that I would try to get written waivers filed. However, we were unaware Friday that these matters were going to be bumped up today. So that has not been done. I do apologize for inconveniencing my client in the court, but we will be standing mute, reading of the information. As for this matter, we set for pretrial conference. As regards to the probation hearings, we ask the court to continue the not guilty pleas that have already been entered and schedule those beyond the 14 days without objection, along with the pretrial in 6693.
Thank you. Very well. Pleas of not guilty will be entered on the defendant's behalf in the 2021 case. The previously entered not guilty pleas in the 2018 and 2020 cases will be continued. A status conference will be scheduled in all three cases to occur at 9 a.m. on Monday, we'll say 9 a.m. On Tuesday, September 7, 2021. The cases are adjourned to the date and time indicated and the bond status is continued.
Thank you.
Thank you, sir. Thank you, Mr. Tigner. Thank you, Mr. Mercedes. Calling the case of People versus Lauren Dean Robinson, file 21-6694-FH. Would counsel identify for the record, please?
Morning, Your Honor. Mark Webb on behalf of the People.
Please, the court, Scott Moore from defense. My understanding is that Mr. Robinson is lodged. I don't know if that's still the case. If so, they're probably, I have no explanation.
Very well. Today is the date and time scheduled for an arraignment in this matter. Mr. Robinson was ordered to be here at 9 a.m. It's now 9:41 a.m. by the court's clock. Mr. Robinson has failed to appear. His attorney was here in a timely fashion. The prosecutor was here in a timely fashion as well. Mr. Robinson has failed to appear without explanation. The court will order Mr. Robinson to appear in court on Tuesday, September 7th at 9 a.m. to show cause why he should not be held in contempt of court for failing to appear here today and why his bond should not be canceled and or forfeited.
Thank you.
Thank you, sir. The bond status will be continued until September 7th. Calling the case of People versus Jacob Michael Kingsley, file 21-6699-FH. In that case, the defense attorney and the defendant had filed a written waiver of arraignment. The court has signed that written waiver pleas of not guilty are entered on behalf of the defendant. As to all counts in this case, the matter will proceed to a pretrial conference. The bond status is continued. The case is adjourned. Calling the case of Heather R. Nelson versus John Edlund, file 20-900285-PP. Counsel identified for the record.
May it please the court, Scott Moore will respond.
Yes, sir, are you John Hedlund?
Yes, sir.
Previously, Mr. Hedlund, you appeared in court, and at that time, the court conducted a hearing back on June 16 of 2021 on an alleged violation of a personal protection order that the court had previously entered in this case. At the conclusion of that hearing, the court found you guilty beyond a reasonable doubt of the criminal contempt of court for allegedly violating the personal protection order. The court scheduled sentencing to occur here today. You appear here today to be sentenced. The maximum penalty the court could impose is 93 days in the county jail. The minimum sentence is discretionary with the court. Along the way, you did retain an attorney after the hearing was conducted, and on your behalf, the attorney, Mr. Moore, filed a motion for reconsideration of the court's decision holding you or finding you guilty of criminal contempt of court for violating the personal protection order. And you appear here today for a hearing on that motion and for sentencing. Do you understand those things, sir?
Yes, sir. Yes, sir.
And Mr. Moore, is there any argument you wish to make in addition to the motion for reconsideration that you did file?
Thank you, Your Honor, and I do appreciate the opportunity to speak to these points. PPO law in Michigan is a matter of statute, which is characteristic of the legislative history. Historically, less than crystal clear. There's very little case law on how to proceed after a finding of guilt. By referring to the various court rules, it appeared to me that we might be able to proceed by way of motion for reconsideration. There's a question as to whether it would be appropriate. I'm uncertain whether this would constitute final order or not. There are criminal court rules that could apply by analogy. In any event, as I've said, I do appreciate the opportunity to address the court on our motion for reconsideration without direct reference to any particular court rule. Your Honor, this case is more complicated than usual. When we were here in August of last year, some of the testimony supported a finding that Ms. Nelson was pregnant, that she believed that Mr. Hedlund was the father, but this was not a life in being. And consequently, at that hearing, which was a motion to terminate or modify, not a violation hearing, the court did grant respondent's motion to modify in part, and noted in the modification that in the event that there was a paternity action filed, and if the Court of Competent Jurisdiction found Mr. Hedlund to be the father of this child, then certain leeway would be given as regards contact for parenting time. The proofs, as I understand it, at the hearing suggested that there was written communication passed through a third party to the petitioner. And the petitioner felt that this was a violation and asked for Mr. Mr. Hedlund to show cause why he should not be held in contempt of court. His violation, if one existed, was not willful, and he was hewing closely to the modified waiver as he understood it. He elected to represent himself at the violation hearing. And I will state for the record that Mr. Hedlund did reach out to my office, but for certain business considerations, no retainer had been tendered and no engagement letter was sent out. So Mr. Hedlund elected, instead of asking for court-appointed counsel or for adjournment, to take care of this himself, because in his mind, he was following the court order as modified. This was not well pleaded by him. And consequently, the court, based on the record before it, found this violation. All I'm asking the court to do with regard to that finding of guilt is to reconsider it in light of the written order of the court, and then determine whether the violation, if any, was willful. Failing that, Your Honor, as I've stated in the pleadings, it appears to me that the court rules require this case to be assigned to one judge. And as I indicated earlier, it is complicated because this action precedes the paternity action. In the normal course of events, the divorce or other similar D-style file would be commenced first, and then the PPO would follow. That's not what happened here. The PPO came first. Then the paternity action was filed, and as the record, the court's files will show, Mr. Hedlund did advise the court through the clerk's office by the docketing statement that there was an existing open PPO case involving the same family members, the same transaction or occurrence. Should have been that this case being the first to have been filed would seem to be the one to control. But given the nature of the relationship between Mr. Hedlund and Ms. Nelson, and the fact that the paternity action, which now embraces elements of custody, child support, and parenting time, will continue until at least the child is 18 years of age, it would seem that the family division should take over both cases. As I stated in the pleadings, and as I state now, I am not taking any position as to which judge should have this case. I am suggesting that the court rules and the case law both are clear that one judge should be managing both files. So for all of these reasons, Your Honor, we are asking the court to reconsider its finding of guilt, that the written orders of the court were substantially complied with by my client, that his failure to advise the court of this at the hearing should not be held against him, given the heightened standard of proof required in such a case, and the possibility of jail or probation, and in the interest of substantial justice. Finally, Your Honor, we do ask the court to instruct counsel, if necessary, or to take it upon the court's own motion to reassign this case either to Judge Klaus or to have Judge Klaus's case reassigned to this court, whichever the interest of justice and judicial economy. Thank you, Your Honor.
Thank you. First, with regard for the motion for reconsideration, at the time that the hearing was conducted back on June 16, the court repeatedly advised the defendant that he had a right to an attorney, and further that if he wanted to have an attorney represent him but was financially unable to hire a lawyer, that the court would appoint a lawyer for him. The defendant, after being fully advised of his rights, elected to proceed without an attorney. At the conclusion of the hearing, the court found him guilty beyond a reasonable doubt of criminal contempt of court for violating the personal protection order. The personal protection order in pertinent part does contain a clause to the effect that, quote, if a court of competent jurisdiction finds respondent has parental rights as to petitioner's minor child, then he may exercise those rights in conformity with that court's orders, so long as he otherwise complies with this personal protection order, close quote. After the court issued its personal protection order, the respondent did participate in a paternity action that had been filed in the Clare County, the Family Division of the Clare County Circuit Court before the Honorable Marcy A. Klaus. Judge Klaus ultimately did find the respondent is the father of the minor child who was born subsequently to the court issuing its personal protection order in this case. And Judge Klaus found that the respondent therefore did have some parental rights. However, the court finds that the manner in which he exercised those parental rights was not in conformity with the personal protection order that this court issued in this file 20-900285-PP. The court therefore finds that its initial finding that the respondent, Mr. Hedlund, was guilty of criminal contempt of court for violating the personal protection order, that the finding of the court reached back on June 16, 2021 is correct, and the court affirms that finding of guilt of criminal contempt of court. We'll proceed with the sentencing today. Is there anything, Mr. Hedlund, you want to say on your own behalf before the court passes sentence?
No, Your Honor.
And on behalf of your client, Mr. Moore?
Thank you, Your Honor. The nature of the violation, handing of a handwritten note indicating a preference as to when holiday parenting time would occur, that being done through the grandmother. It's not intended to harass, molest, otherwise intimidate, terrorize the respondent, petitioning mother. We would ask the court's guidance in how to proceed further so that we don't have these problems, so that there is better coordination between the two members of the court. In light of all of this, Your Honor, I do not believe that probation is necessary, nor is incarceration, rather a monetary fine. We believe further the authority of the court and reinforce from my client how that he must follow the order to the letter. Thank you.
Thank you, sir. Mr. Hedlund, in order to punish you for what you've done and to deter you and others in the future from defying court orders and or committing crimes, and to give you the opportunity to rehabilitate yourself, it's the sentence of the court. You will be placed on probation for a period of 6 months. In addition to all the statutory terms of probation, you also must abide by all the written terms of your probation order as well, which will include but not be limited to, you must follow all the terms and conditions of the personal protection order in this case. You must pay $30 per month for any probation oversight fees, and for any period of time during which you are placed on electronic monitoring, you must pay $60 per month. I'm not going to impose any other fines or costs or fees. And you've retained your own lawyer, so there are no court-appointed attorney fees to deal with it. Do you have $180 today to pay the probation oversight fees?
I could have it at the end of the day, Your Honor.
Very well, then the entire $180 must be paid by 4 p.m. today. That will be a condition of your probation. If it's not filed, you can fully expect to be charged for violation of probation. But I don't expect that to occur because you've assured me that you can and will pay the $180 by close of business today. That will be the sentence of the court. It's my duty to inform you, Mr. Hedlund, that you are entitled to appellate review of your conviction and sentence, and if you're financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. That will conclude the court's sentencing in this matter. However, Agent McConnell might have some additional instructions to give to you. Do you have any such instructions, Mr. McConnell?
Thank you, Your Honor. Mr. Hedlund, I have your contact information. You need to contact me between 3 and 4 p.m. today by phone.
Yes, sir.
Thank you, Your Honor. I have nothing further.
Yes.
Thank you, Mr. Hedlund. Thank you, Agent McConnell. That concludes the sentencing. Now, with regard to the request for relief and the motion for reconsideration, I've denied the motion for reconsideration. However, as a subpart of the prayer for relief, the attorney for the respondent, Mr. Moore, did request that the court consider assignment of this case consistent with Michigan Court Rule 8.111 and applicable case law, which would basically entail, as Mr. Moore indicated, either that I assign the PPO case to Judge Klaus, or that Judge Klaus assign the paternity case to myself. I will confer with Judge Klaus, and I will take under advisement that portion of the prayer for relief, and I would expect to confer with Judge Klaus regarding whether that prayer for relief should be granted or not. Thank you, Mr. Moore.
Thank you.
Mr. Hedlund.
The record should reflect that my client has decided to proceed from notice of appellate rights and return to the second office.
Thank you, Mr. Moore. Good luck to you, Mr. Hedlund.
Thank you, Your Honor.
Yeah, we're gonna just,
Sure, sure.
Thank you, Your Honor.
Thank you, sir. Calling the case of People versus Judith Elizabeth Conaway, file 21-6606-FC, -FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
May it please the court, Scott Moore for the defense.
Ms. Conaway, would you please raise your right hand to be sworn, ma'am?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Could you tell us your name, miss?
Judith Elizabeth Conaway.
Your Honor, before we proceed with the plea, in candid of the court, I do see that this was scheduled for a show cause hearing. If I may refresh the court's memory, my client had been ordered to appear in person. She had been in continual contact with my office since before the courthouse opened, indicating that her ride had fallen through and she was making efforts to come. Those were unavailing. She then tried to participate in that hearing by Zoom, but her cell coverage was very poor. And so the court, at my request, rescheduled this matter for what we hope would be a plea, but at least a status conference. So as regards the contempt, it is counsel's position that she exercised due diligence to be in court as ordered. She was unable to do that. She then tried to at least participate electronically from a remote location, but was unable to because of technical limitations. So for those reasons, there was no contempt toward the court that was indicated on the line.
Thank you, sir. Well, the court does note that the court had ordered back on June 21, 2021, that the defendant must appear in person on July 19, 2021 in court. She failed to do so. However, in light of the explanation the defense attorney has tendered here on the record, the court will dismiss without prejudice its order that the defendant appear here today to show cause why she should not be held in criminal contempt of court. And did you want to proceed then by way of entry of a plea, Mr. Moore?
No, Your Honor, for the following reasons. I had spoken with my client at my office. We were on the telephone quite a bit yesterday. Frankly, Your Honor, this would be a constructive possession case. Two other co-defendants have been charged. There might have been a preliminary examination of one of those. Because of the nature of the offer, it appeared to counsel that we would accept that offer and enter a plea today. My client, though, has serious and legitimate concerns about the evidence against her, certain inconsistencies regarding the existence of video and the like. So we are not intending to delay this case for delay's sake. However, because of the burden of proof that faces the people and my client's questions about the evidence against her and the statements that may be brought to bear, we are not prepared to enter a plea to accept the offer. We do recognize that this offer may be withdrawn and never offered again. Is that correct? But you believe you are innocent, or at least people cannot prove you guilty on reasonable doubt. Is that correct? You understand that there are grave penalties that will attach if you are found guilty. So with that, Your Honor, we would ask the court either to schedule a status conference or set for final pretrial on the trial docket.
Very well, the case will proceed to a status conference, and bond status will be continued. Ms. Conaway, it's a free country. You're free to make your own decisions. Yeah, but I would advise you to discuss things thoroughly with your lawyer. Perhaps you've already done that. If you are found guilty, as he alluded to, you face some very serious consequences. The maximum penalty is 10 years in the state's prison. The minimum sentence is discretionary with the court. Thank you for being here, miss.
Thank you.
Make sure you stay in touch with your lawyer, Mr. Moore. Calling the case of People versus Robert Allen Williams Jr., file 21-6560-FH. Would counsel identify for the record, please?
Show them size for the people.
And this court, Scott Moore for the defense. May counsel approach you?
Sure.
Thank you. Yeah, Roger. Roger. Not Robert. Roger.
I saw Alicia was here for a second. What I'd like to do is pass this matter. Have the lawyers get involved. I'd like to track down Alicia and see if I can get resolution.
Very well, then we'll pass on this matter involving Mr. Williams for the time being. And thank you for being here, Mr. Williams. But don't leave. Don't interpret what I said as being your go ahead to leave, because we'll be returning to your case later. Calling the case of People versus Andrew Walter Davison, file 21-6675-FH. Would counsel identify for the record, please?
Show them size for the people.
And this court, Scott Moore for the defense. No plea today. If we could conduct the pretrial, I appreciate it.
Very well, do you want the matter scheduled for a jury trial, Mr. Moore?
Yes, Your Honor. I anticipate no more than 2 days.
All right.
There was no preliminary examination.
Thank you, sir. Very well then. Anything further you wanted to add at this time, Ms. Ambrositis? Very well then, the court has signed a pretrial summary order in this matter. The case will proceed to trial. Thank you for being here, Mr. Davison. Make sure you stay in touch with your lawyer, Mr. Moore. And calling the case of People versus Anthony Benjamin Garn, file 20-6489-FH. Would counsel identify for the record, please?
More, Your Honor, Mark Webb on behalf of the people.
This court's coming up to the defense.
Does Mr. Garn appear here today?
Is here remotely.
I'm here, Your Honor.
I
Thank you, sir.
beg the court's pardon, whether the court had ordered him to be here in person or I had requested it. In any event, this matter was scheduled for hearing yesterday. My client had made arrangements to be here. When the cases from yesterday's docket were rescheduled for today, we were unaware of that. When that happened, we had anticipated that this matter would be put out next week so that we could make those new arrangements. Given the press of time, my client was unable to do that, so that's why he is appearing remotely.
Thank you, sir. Do you wish to proceed today remotely, Mr. Moore, or did you want an adjournment of the sentence?
Mr. Garn, you have a right to be here in person. You can waive that right and we can proceed to sentencing. What would you prefer?
Yes, I will waive that
All
right.
right. We will proceed.
I would prefer to be sentenced.
All right, thank you, Mr. Garn.
Sorry I couldn't be
That's
there.
okay, sir. Sir, in this case, first, are you Anthony Benjamin Garn?
Yes, Your Honor, I am.
Mr. Garn, back on April 19, 2021, you appeared in court, and at that time, you pled guilty to the crimes of possession of less than 25 grams of cocaine and to being a habitual offender, second offense notice. You appear here today to be sentenced. Ordinarily, the maximum penalty the court could impose for a conviction of possession of less than 25 grams of cocaine would be 4 years in prison and/or a fine of up to $25,000. However, and the minimum sentence would be discretionary with the court. However, unless the court sentenced you to more than 1 year in prison, then the court must impose driver license sanctions according to Michigan compiled law 333.7408A. Ordinarily, that would be the maximum and the minimum sentence the court could impose. However, because you also pled guilty to being a habitual offender, second offense notice, the net effect of that is that the court in its discretion could raise the maximum penalty from 4 years in prison to 6 years in prison, and could raise the maximum fine from $25,000 to $37,500. It would be discretionary with the court whether or not to raise the maximum end of the sentence. And regardless of whether the court did so, the minimum end of the sentence still would be discretionary with the court. Although unless I sentenced you to more than 1 year in prison, then I must suspend or revoke your driving privileges pursuant to Michigan Compiled Law 333.7408A. Do you understand those things, Mr. Carn?
Yes, Your Honor, I do.
Now, the Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 0 to 21 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. You understand everything we've talked about, Mr. Garner?
Yes, Your Honor, I do.
Mr. Moore, have you gone over both of these reports with your client?
Yes, Your Honor.
Is there anything in either report of a factual nature that you want to add to or explain or contradict?
No, Your Honor.
Do you have any challenges to the scoring of the offense variables or the prior record variables, or the calculation as to the applicable sentencing guideline range as being 0 to 21 months?
No, Your Honor.
And on behalf of the people, Mr. Webb, I pose that same series of questions regarding the reports to you.
Your Honor, I reviewed the report, I have no additions or corrections to make to it, and I also reviewed the guidelines are correct.
Thank you, sir. Mr. Garn, is there anything, sir, you want to say on your own behalf before the court passes sentence?
Yes, Your Honor, I accept full responsibility for what I did from the start and to the beginning. You know, I have a 15-month-old child and one on the way in January, and I have been focusing, and, you know, I apologize, you know, for what I've done, and I'm sorry for costing the court time and money, and I'm going to do what I can to rehabilitate myself, and so this never happens again.
Thank you, Mr. Garner. And I apologize for taking matters out of sequence, but the court does have one small correction to make to the report, PSI report, which would be page 1 of the CFJ 284 in the second paragraph entitled plea agreement. In the very first sentence, It indicates the defendant pled guilty on April 19, 2021, ellipsis, to count 1, controlled substance possession of cocaine less than 25 grams. I would suggest adding to the conclusion of that sentence, plus habitual offender second offense notice. Do you have any objection, Mr. Moore?
No.
Or Mr. Webb?
No, Your Honor.
Very well, the court will make that change and direct the department to make that addition as well. And again, I apologize for disrupting your train of thought, Mr. Moore.
Actually, Mr.
Garn,
Garden was allocated for himself. I haven't spoken.
thank you. Mr. Garden has spoken. Mr. Moore, is there anything, sir, you want to say on your own behalf, on behalf of the client? That's right. I throw myself on the mercy.
About the average time, that's,
Thank you, Mr. Moore.
thank you, Your Honor. I will ask the court to follow the Killebrew agreement. The report notes that a substance abuse assessment was completed. My client's own initiative, and that was taken into account by the department. Put that forth to show that he is serious about getting in front of these problems. And as the report indicates quite correctly, my client relies on his ability to drive in order to earn a living. So I would ask the court to impose the minimum period of a hard suspension to allow my client a restricted license, and as soon as possible under the existing law. Thank you.
Thank you. And on behalf of the people, Mr. Webb?
Thank you, Your Honor. I would just ask you to follow the plea agreement and the recommendations by the probation department.
Very well, Mr. Garn, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself. It's the sentence of the court. You will be placed on probation for a period of 2 years. You must obey all the statutory terms of probation as well as all the written terms of your probation order as well. All of those terms include, but are not limited to, you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to alcohol and drug testing on demand. You must attend and successfully complete any substance abuse treatment program to which you are referred by the probation agent, and give up any confidentiality right in any such program so that the court may monitor your progress. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, and you must not possess any weapons or copies of weapons. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must not change your approved residence without first getting permission from the probation agent. You must submit to a search of your person and property without the need of a search warrant. And further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe that you are conducting yourself in a manner inconsistent with the public good. You must seek and maintain full-time employment and or be enrolled in a full-time education program. You must not drive a motor vehicle unless you first obtain written permission to do so from the probation agent. Further, your driver's license will be suspended or revoked according to Michigan compiled law 333.7408A. I'm not sure the court really has a role in determining how long that suspension or revocation will be for, but the court recommends that it be for the minimum duration required under the law.
Much appreciated, Joe.
Thank you, Mr. Moore. You must pay $68 in state costs and a crime victims assessment of $130. You must pay a probation oversight fee of $30 per month for each month that you are on probation, rising to $60 per month for each month while you're on probation if you are being supervised under electronic supervision. You must pay court costs of $500, a fine of $500, and court-appointed attorney fees of, do you have an estimate, Mr. Moore?
Yes, Your Honor. $460.
Court-appointed attorney fees of $460. Now, how much of that approximately $2,100 do you have available today, sir, to apply towards your court-ordered money?
Oh, you said $2,100?
Approximately, I'm just guesstimating.
Well, when
Yes,
I
sir.
get paid on Friday, I could make a $100 payment.
Okay, and then will you be able to pay $100 per month thereafter?
Yes, sir.
All right, you must pay $100 minimum on towards your court-ordered monies on Friday, on or before Friday, August 6th. And then you must pay an additional minimum payment of at least $100 by 12 noon on the 6th day of each month thereafter until the money is paid in full, but it all must be paid by the time you get off of probation. Now, sir, it's my duty to inform you that you are entitled to appellate review of your conviction and sentence, and if you're financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Now, it was implied in what the court has sentenced, but I will make it explicit. I'm not going to sentence you to jail today, Mr. Guard. I will honor the Briggs-Killebrew agreement, which provided that there would be no initial incarceration. Good luck to you, sir. That will conclude the sentencing. However, Agent McConnell from the probation department might have some additional instructions to give to you. Agent McConnell?
Thank you, Your Honor. Mr. Garn, you need to contact me between 3 and 5 p.m. today.
Yes, sir.
All right. Thank you, Your Honor.
Thank you, sir. Good luck to you, Mr. Garn. Bond
Thank
is
you, Your Honor,
canceled.
and I appreciate it.
You're welcome, sir. Bond is canceled and any bond posted in the defendant's own name will be applied towards court-ordered monies. Good luck, Mr. Garn.
Thank you, sir. You have a good day.
You too, sir.
Good luck, Anthony.
Thank you, Mr. Moore. I appreciate all you've done.
Calling the case of People versus Clayton Robert Brady, 21-6618-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
Sure.
What'd you say?
Could you approach? Very well, we'll pass on the matter of People versus Reed. Until later this morning.
We'll be back, Mr. Weaver. We'll answer some questions.
We have one case is he's the age, if you don't mind, because regarding the cases of People versus numbers 21-6687. The court will pass on those matters for the moment and revisit them later this morning. And calling the case of the two cases of People versus William August Kettner, file 20-6426-FH and file 20-6427-FH. Would counsel identify for the record, please?
Morning, Your Honor, Mark Webb on behalf of the people.
Morning, Your Honor. Gerald White representing Mr. Kettner.
And Mr. Kettner appears here in person in the courtroom. Mr. Kettner, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you tell us your name, sir?
Yes, William August Kettner.
Thank you, Mr. Kettner. Mr. Kettner, you appear here today because you failed to appear in court back on July 13 of 2021 in each one of these two files as previously ordered by the court. And as a consequence, then the court issued an order requiring you to appear here today to show cause why you should not be held in criminal contempt of court for failing to appear back on July 13, and also to show cause why your bond should not be canceled and or forfeited. Mr. White, do you want to proceed on that show cause, or do you want to proceed by way of entry of a plea to the underlying charge or charges, or how would you like to proceed, sir?
Your Honor, if it pleases the court, I have a motion before the court to withdraw as counsel for Mr. Kettner. I have filed a similar motion before the district court, which was granted last week, withdrawing as counsel for Mr. Kettner. I have received a communication from the court, a trial list, which indicates that Mr. Kettner has been appointed an attorney by the name of Howe, H-O-W-E, whom I am not familiar with. But I have a motion today on the two files that Mr. Kettner is appearing on before the court. And I'm making this motion because of a communication breakdown between Mr. Kettner and myself on an impossibility of trying to resolve these cases that have been before the court for almost a year at this point in time. There has been a pretrial summaries initiated by the prosecuting attorney's office of Clare County, giving offers to Mr. Kettner to resolve these matters, and we cannot come to a fair resolution from my standpoint on behalf of Mr. Kettner. So I'm making the motion to withdraw.
Kettner, do you have any objection to Mr. White withdrawing as your attorney in this case? Okay. Do you have any position in this case, Mr. Webb?
No, thank you.
Very well then, with regard to Mr. White's motion to withdraw as the attorney of record in each one of these two cases, the court grants that motion and has signed an order to that effect. Substitute. Well, Mr. Kettner, are you going to hire an attorney to represent you, sir?
No, I've been, attorney has been represented to me. I don't remember her name. She called me yesterday on the phone and I talked to her.
Is it Annette Howe or is it
Yes, I think
someone
it
else?
is. Yes, it is. This is Your Honor.
All right. Well, Ms. Howe is on the case that she was appointed to represent you on, sir. Was that here in Clare County or was it in Gladwin County?
No, too. Very good.
All right. Well, thank you, sir. I'm not sure what lawyer the court will appoint, but the court will appoint a lawyer to represent you. However, I want you to understand, sir, in file 20-6426-FH, you are charged in count 1 with delivery of less than 50 grams of fentanyl. That crime is a felony and ordinarily would carry a maximum penalty of 20 years in prison. However, you are charged with second or subsequent offense under the Michigan Controlled Substance Act. So as a consequence, the maximum penalty would be doubled from 20 years in prison to 40 years in prison. Similarly, in count 2, you are charged with delivery of methamphetamine, second or subsequent offense. Delivery of methamphetamine is a felony, ordinarily carrying a maximum penalty of 20 years in prison. However, with the second or subsequent offense notice, the maximum penalty would be doubled to 40 years in prison. With regard to count 3, you're charged with possession of methamphetamine, second or subsequent offense notice. Possession of methamphetamine is a felony, ordinarily punishable by a maximum of 10 years in prison. However, because of the second or subsequent offense notice, you would be facing a double penalty of up to 20 years in prison. You understand that?
Yes, Your Honor.
Finally, in count 4, you're charged with possession of less than 25 grams of fentanyl, second or subsequent offense notice. Possession of less than 25 grams of fentanyl is a felony and ordinarily would carry a maximum penalty of 4 years in prison. However, because of the second or subsequent offense notice, the maximum penalty would be doubled to 8 years in prison. Do you understand those things?
Yes, sir.
The reason I go to the trouble of advising you of these things, of which you've already been informed in the past when you were arraigned, is that in the near future, you're going to have another lawyer representing you. Somewhere along the way, things went to hell in a handbasket in your relationship with Mr. White. And that relationship broke down. I don't know why, and it doesn't really matter, but I want you to get off on the right foot with your new lawyer, and I want you to sit down with her or him and discuss fully and frankly where you stand on these two cases. And I did not go through all of the charges in file 20-6427-FH, but in that file, you're charged with possession of methamphetamine, second or subsequent offense notice. Possession of methamphetamine is ordinarily a 10-year felony, but because of the second or subsequent offense notice, you would be facing up to 20 years in prison in that case also. The reason I go through all of this, once again, is because I want you, when you sit down with your new lawyer, to be candid with her or him and to listen carefully to anything she or he says to you. You understand all those things, sir?
Yes, I do.
Very well, then, bond will be continued in this case, and the case will proceed to a status conference in each one of the two cases. Good luck to you, Mr. Kettner. Thank you for being here, sir.
Okay, do I still have, a case on the 18th?
Is that in the district court,
I'm not
or
sure.
is that in this court?
I thought it was in this court, but I'm not sure.
Thank you for asking, sir. The only two things I do see that you had been scheduled for a jury trial in one or both of these cases to take place today, Tuesday, August 3rd. Those jury trials were adjourned because of the motion to withdraw filed by your lawyer and possibly other reasons as well. So we will, before we go to a trial on these two cases, we'll at least have a status conference with your new lawyer. And as far as I know, sir, you're not required to be here in this courtroom on August 18th.
Okay, I'll check the other report before I leave.
Okay, thank you, sir.
Thank you.
Good luck to you.
Thank you.
Mary, is Mr. Reed up? Jail said they have been kicking him out. Is Mr. Reed up?
We have to.
Oh,
We
okay,
have
because the
to.
jail said it kept on kicking him out.
I put him in the waiting.
Oh, okay.
Thank you. Calling the case of People versus Ashton K. Emberton, file 21-6658-FH. Would counsel identify for the record, please?
Sean presides for the people. I don't see Mr. Diedrich online.
Thank you, Ms. Ambrositis. I don't see him either. I guess I was on autopilot and calling the case. So we'll return to that case a little bit later then. Mr. Dietrich?
Morning, Your Honor.
Thank you. Regarding the case of People versus Ashton Christopher Pemberton, file 21-6658-FH. That case is scheduled for a conference. How do you want to proceed in that regard, Mr. Dietrich?
Your Honor, I apologize. So I got a lot going on at the moment. I kind of double booked with being at district court at the exact moment as well. I do need to speak to all my clients in a breakout room before each case, but I was hoping that Mr. Emberton might be a plea today.
Okay.
But could they actually just, so I've been waiting in both courts and they called my case in district court and the magistrate's waiting for me. And I don't know if this court will allow me to take a moment to resolve that. That should be a relatively quick matter. It's just an arraignment.
Absolutely. Take your time in district court, Mr. Dietrich. Thank you for being here. We'll pass.
Thank you very much.
Thank you, sir. And so I believe then that would either take us back to Mr. Moore's cases or to proceed to Ms. Tomczyk's. And I don't know. Would you like to proceed, Ms. Tomczyk?
Your Honor, I think we're waiting on Mr. Lane to get here. However, Mr. Bailey and Mr. Risch are lodged.
Okay.
Oh, as is Mr. Wright. So we could proceed with those cases.
Okay, well then, is there a problem with that? If we go ahead with the Wright and the Risch cases?
Do you want me to go ahead and call?
Yes, they lock that out. So waiting until we're back.
Which one do you want?
We're going to start with Rex Bailey.
Bailey?
Is-
Court Security to Corrections.
Bailey as well.
Yes.
Thank you. Thanks, Ms. Archie.
The jail has to log in.
Thank you. Is this the?
It is, I'm just looking for, yeah.
Mary, can you hear?
Trying to go back
Mr.
over
Reed,
the offer. and
is
what
it
one
the
is.
jail certificate?
I don't have the jail at all.
Oh, it's not on it.
They need to log it in.
Okay.
You know what, I'll see you briefly.
Yeah, that's what I was looking for, Your Honor. I know when I went over with the offer in the district court, he said he was all right with it, so.
I don't see it on PCC.
Huh?
The jail's trying to clean.
You don't see PCC?
Rex Bailey. So
Count
they're
one possession,
They're
not
bringing
to
it to
DD. Since agreement for count one, only a 1-year delay. The completes the delay charge reduced to 1 year misdemeanor use of that or sentence agreement as to the DD. Restitution be determined.
And with regard to one, would that be possession of methamphetamine, second offense? You can have them one this.
I think it was. I think it's,
There was an arraignment today.
That's okay. And
yeah, that's fine. That's Mr. Reed.
Yes, Bailey.
I'm pushing regional summary for Emberton to the law library printer.
thank you.
You're waiting on IT to get over there to. In that 10 minutes now.
I mean, we had to go do some more the old fashioned way last night. They actually drove it to my house.
Michelle, do you want me? That's what
Say something relevant. Go along.
Should we stand?
Waiting on them. Might as well take a break.
We'll be in recess.
All rise. All rise. Court's back in session. Honorable Thomas R. Evans, presiding.
Good morning, you may be seated. Recalling the case of People versus Ashton K. Emberton, file 21-6658-FH. Would counsel identify for the record, please?
Members, I just bring back people.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Emberton.
Mr. Emberton, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Could you tell us your name, sir?
Ashton Emberton.
Thank you, Mr. Emberton. Today is the date and time scheduled for a pretrial conference. How did you want to proceed, Mr. Dietrich?
Your Honor, there's a plea that's been made, a plea offer that's been made that Mr. Emberton would like to take advantage of.
And would this be a plea of guilty to possession of methamphetamine?
Yes, Your Honor.
Very well, Mr. Emberton, do you understand that according to, do you have any objection, Mr. Webb, if I amend the information on the record by inserting the words count one before controlled substance possession of methamphetamine? I'm sorry, Ms. Ambrositis' case. It's just a matter of style in some ways, but the information does not specifically indicate count one.
That's fine, Your Honor. Our new system does not put a count in if there is only one on there.
Thank you, ma'am, which is, do you have any objection, Mr. Dietrich?
No, Your Honor.
Very well, the court will amend the information on the record by designating the first and only count that is in the information as being count one. Mr. Emberton, do you understand that according to count one, you are charged with possession of methamphetamine?
Yes, Your Honor.
Now, that crime is a felony and it carries a maximum penalty of 10 years in prison and or a fine of up to $15,000. You understand that?
Yes, Your Honor.
The minimum sentence would be discretionary with the court. However, unless the court sentences you to more than 1 year in prison, then the court must impose license sanctions pursuant to Michigan Compiled Law 333.7408A. Do you understand those things, sir?
Yes, Your Honor.
Now, with regard to count one, possession of methamphetamine, you may make any of the following three pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas you may make to count one, sir?
Yes, Your Honor.
Then answering to count one, possession of methamphetamine, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, Your Honor.
The court also informs you that if your plea of guilty is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights: the right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial and for you and your lawyer to have the chance to question and cross-examine each of those witnesses. The right to have this court order any witnesses that you might want for your defense to be required to appear at the trial. The right to remain silent and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Emberton?
Yes, Your Honor.
And do you understand, sir, that by pleading guilty to count one, that means you'll be giving up each and every one of those rights?
Yes, Your Honor.
Now, sir, I'm going to ask your lawyer, Mr. Dietrich, and the elected prosecuting attorney for Clare County, Ms. Michelle Ambrositis, to tell us what the plea agreement is. And I want you to listen to both of them very carefully. Ms. Ambrositis, what is the plea agreement?
You're in return for the defendant's plea of guilty as charged, he would agree pursuant to Briggs and Killebrew that he would receive the benefit of 7411 status. Other terms and conditions are that he is to testify truthfully against the Angelica Pitt when called upon to do so.
Mr. Dietrich, is that your full and complete understanding of the plea agreement?
Yes, Your Honor.
Now, Mr. Emberton, did you hear what the prosecuting attorney and your lawyer said the plea agreement is?
Not entirely.
Well then, sir, what we're going to do, I'm going to ask the prosecuting attorney to repeat herself, and I'm going to ask your lawyer to repeat himself, and we'll place the agreement on the record, and I want you to listen very, very, very carefully. And if at any point in time you cannot hear what's being said, I want you to raise your hand and signal to the court that you can't hear what's being said, rather than waiting until everything has been done all over again and then letting us know. Okay? Ms. Ambrositis, would you please tell us what the plea agreement is, ma'am?
In return for the defendant's guilty plea as charged, the people would agree pursuant to Briggs and Killebrew that there would be 7411 status applied. Defendant is to testify against the Angelica Pitt truthfully when called upon to do so.
Mr. Dietrich, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Emberton, did you hear the plea agreement that was placed on the record?
Yes, Your Honor.
Did you understand the plea agreement?
Yes, Your Honor.
And do you agree with that plea agreement?
Yes, Your Honor.
Now, has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No, Your Honor.
So, for example, sir, has anyone promised you that if you plead guilty to count one, that this court then would be lenient or light on you in any way?
No, Your Honor.
Has anyone threatened you or your family to get you to plead guilty?
No, Your Honor.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you, sir?
No, Your Honor.
Do you understand everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still want to plead guilty to count one?
Yes, Your Honor.
Very well then, sir, drawing your attention back to on or about May 25th of 2021, were you in Hayes Township in Clare County, Michigan?
Yes, Your Honor.
On that day and at that location, did you have some methamphetamine in your possession?
Yes, Your Honor.
At the point in time when you were in possession of the methamphetamine, did you know that it was methamphetamine?
Yes, Your Honor.
Did you have any legal right or justification or mitigation permitting you to possess the methamphetamine?
No, Your Honor.
Mr. Dietrich, are you satisfied that there is a sufficient factual basis to accept the plea of guilty?
Yes, I am, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Mr. Dietrich, has the court complied with the court rule in the taking of the plea?
Yes, it has, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor or the defendant or the defense attorney or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty to count one, possession of methamphetamine, is accepted and ordered entered on the records of the court. Sentencing will occur on Tuesday, September 7 at 9:40 a.m. Bond is canceled and the case is adjourned to the date and time indicated. That will conclude the plea taking process, Mr. Emberton, except that the probation agent, Mr. McConnell, might have some additional instructions to give to you. Agent McConnell?
Thank you, Your Honor. Mr. Emberton, is your address still at 612 Harrison Street?
No, Your Honor.
Mr. Emberton, are you still on Harrison Street?
No.
What is your current address?
11584 East Monroe Road.
What city is that in?
Britain, Michigan.
In Clinton?
Britain.
And what is your current phone number?
Hold on, let me. Seven 807-0783.
All right, you'll be getting a packet in the mail. You need to follow those instructions completely and contact the agent that's listed on that packet. Do you understand that?
Yes.
Thank you, Your Honor. I have nothing further.
Thank you, Agent McConnell. Thank you, sir. Mr. Emberton, and the case will be adjourned to the date and time indicated. Bond is canceled. Calling the cases of People versus Lisa Mulholland, file 20-6498-FH. Just a moment, ma'am. And People versus.
And it's on and off, and it's burning when I hear it. It's not as bad as last time, but at the beginning, but it's mild out, and it seems like it slowed down the day after the shot or the pill.
Lisa, is that noise coming from you?
Yeah, I think so.
The background's gonna have to be silent if possible, please.
Okay.
Yes.
Calling the cases of People versus Lisa Marie Burzak, file 20-6504-FH, and People versus Lisa Marie Mulholland, file 20-6498-FH. Would counsel identify for the record, please?
Thank you, Your Honor. Todd Dietrich. Oh, sorry.
Morning, Your Honor. Mark Glenn on behalf of People.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Miss Burzak, also known as Miss Mulholland.
Ms. Burzak, AKA Ms. Mulholland, would you please raise your right hand to be sworn, ma'am?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name, miss?
Lisa Marie Burzak.
Thank you, ma'am. You may lower your hand if you'd like. Mr. Dietrich, today is the date and time scheduled for a status conference in these two cases. Are we proceeding by way of a plea or in some other fashion?
Not yet, Your Honor. Ms. Burzak is currently in an inpatient treatment program. And I did receive an email from, I think it was Ms. Brubaker, I believe it was from, suggesting that we adjourn the matters today. We would have no objection in doing that. There is an underlying case that is still in district court at this time.
Okay, when do you expect the underlying case to be resolved?
Either resolve or be waived up to circuit court, I'm assuming within 45 days, Your Honor.
Yes, I would like to make an appointment to come in to get back. I was in on the 22nd, and all my tests are negative. And right now, I still have so much plate to and tomorrow would be great.
All right, then we'll schedule these two matters, these two cases for a status conference on Monday, October 18, 2021 at 9:40 a.m. Will that work for you, Mr. Dietrich?
124.76.
That should be fine, Your Honor.
Thank you, sir. The cases will be adjourned to the date and time indicated. The bond status will be continued. Ms. Mulholland, AKA Ms. Burzak, make sure you stay in touch with your lawyer, and we'll see you in these cases then in October.
Yes, sir. Thank you.
You're welcome, miss. Thank you. Okay. Is that the matter you'd like to address next? Mr. Dietrich, regarding the two cases of People versus William Sheldon Shook, file 20-6518-FH and file 21-6663-FH. Mr. Shook, I believe, is scheduled to be sentenced in each of those matters. Do you need to confer with him before the sentencing?
I do, Your Honor. I apologize, but I do. Yes.
That's quite all right, sir. We'll take a break then and probably, and we'll allow you to confer privately with Mr. Shook.
All rise. All rise. Court's back in session. Honorable Thomas R. Evans presiding.
Good morning, you may. In which case would you like me to proceed with, Mr. Dietrich?
Your Honor, it might be beneficial to start with file, the domestic violence file, which is 20-6518-FH.
Okay. And what is your name again, sir?
William Sheldon Shook.
Thank you. Mr. Shook, you appear here today in file 20-6518-FH to be sentenced, and also in file 21-6663-FH to be sentenced as well. In file 20-6518-FH, Previously, you appeared in court way back on December 14 of 2020. And at that time, you pled guilty to the 5-year felony crime of domestic violence through defense notice. You appear here today to be sentenced. That crime is a felony. It carries a maximum penalty of 5 years in prison. The minimum sentence is discretionary with the court. And the Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, the departments calculate your applicable sentencing guideline from 0 to 17 months, although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Do you understand those things, sir?
Yes, I do, Your Honor.
Now, in file 21-6663-FH, you appeared in court in that file back on June 21, 2021, and at that time, you pled guilty to the 5-year felony crime of aggravated stalking. You appear here today to be sentenced in that file as well, and Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report in that file. And in those two reports, the departments calculate your applicable sentencing guideline range, at least thus far, as being 7 to 23 months. Although pursuant to People versus Lockridge, the sentencing guidelines in each of these two files are now advisory rather than mandatory. Do you understand all of those things, Mr. Shaw?
I do, Your Honor.
Mr. Dietrich, have you gone over these 4 reports and these 2 files with your client?
I have, Your Honor.
Is there anything of a factual nature in any of the reports that you want to add to or explain or controvert?
Your Honor, I do apologize. I worked this out with Mr. McConnell here a moment ago, but in the sentence information report for docket number 20-6518FH, there was a lot of confusion as to Mr. Shook's prior criminal record and whether or not he had a felony, but it was determined that he does not have a prior felony prior to this date. And they looks like they inadvertently forgot to take off the PRV2, which was 5 points. I believe that should be scored at 0 points, leaving a total PRV of 15. And I to advance my apology, I don't know if that changes the guideline range at this moment.
Okay. And do the people have any objection to the court amending the sentencing information report in the 2020 case to change PRV2 from 5 points to 0 points?
I have no objection.
Very well, the court will make that change. And then in addition, the total PRV points, instead of being 20 points, would now be 15 points. Is that correct, Mr. Dietrich?
Yes, Your Honor.
And Ms. Ambrositis?
Correct.
And as a parenthetical matter, well, I guess not parenthetical, then the total for the PRV level, when it was 20 points, was calculated as being PRV level C. do you know, Agent McConnell, now that the total PRV points have been reduced to 15, would this still be a PRV level C, or would it be reduced to a level B?
Your Honor, according to my sentencing guideline manual of 2018, it would still be under a level C, C being 10 to 24 points, Your Honor.
Thank you, sir. And the prosecutor also opined that it would be a PRV level C. And therefore, do you agree, Mr. Dietrich?
Yes, Your Honor. Thank you. I appreciate that.
Thank you, sir. So the cell into which the defendant falls would be level or cell C, Roman numeral 3, and the guideline range would remain 0 to 17 months. Is that correct, Ms. Ambrositis?
That's correct.
And Mr. Dietrich?
Yes, Your Honor.
Is there anything else in any of these 4 reports that you want to add to or explain or contradict, Mr. Dietrich?
No, Your Honor.
Very well, the court has made changes to its copy of the sentencing information report, changing PRV from 5 points to 0 points, and the total PRV points from 20 to 15. And I would ask the department to do so as well. Mr. Dietrich, in each one of these 2 files, do you have any other challenges to the scoring of the prior record variables or the offense variables or the calculation as to the applicable sentencing guideline range in the 2020 case as being 0 to 17 months and the calculation in the 2021 case as to the applicable sentencing guideline range being 7 to 23 months? Do you have any challenges, sir?
No, Your Honor.
And Ms. Ambrositis, on behalf of the people, I would pose those same questions to you.
Your Honor, we've had the opportunity to review the pre-sentence investigation reports, which we find them actually accurate. And outside of the agreement to the change of scoring in the 6518 FH file, we have no other issues with the PRVs or the offense variables.
Thank you, ma'am. Mr. Shook, is there anything, sir, you want to say on your own behalf before the court passes sentence?
I don't believe so, Your Honor. Thank you for the opportunity.
Thank you, sir. And on behalf of your client, Mr. Dietrich, in these 2 files?
Just, Your Honor, Mr. Shook, he seems to be a relatively nice person. He's always been very courteous, and we've had a lot of talks about how he ended up in this particular situations. And he's advised me that he's made plans to provide for himself and stay busy and stay out of trouble. And so I'm hoping that he follows his own thought process and he's able to do that. And with all that said, I would ask that the court follow the agreements between the parties.
Thank you, sir. And on behalf, well, first, are there any victims present who wish to speak to the issue of sentencing? The record should indicate no response. Second, on behalf of the people, Ms. Ambrositis.
We ask to follow the recommendations and the plea agreement in these matters.
Thank you, ma'am. Very well, sir. In order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court in each one of these 2 files. You'll be placed on probation for a period of 5 years. Those 2 5-year probationary periods will run concurrently to one another. And except as otherwise noted, the terms and conditions of each probation order will be identical. Those terms include but are not limited to, you must follow all the written terms of your probation order as well as all the statutory terms of each probation order, including but not limited to, you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to alcohol and drug testing on demand, and you must successfully complete any substance abuse treatment program to which you are referred by the probation agent, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not possess any weapons or copies of weapons. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must not change your residence without first getting written permission to do so from the probation agent. And you must submit to a search of your person and property without the need of a search warrant if the probation agent has reason to believe you have violated your probation. Further, the probation agent does have the right to arrest you if he has reason to believe you have violated your probation orders, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. In each file, you must abide by a curfew and be within your approved residence between the hours of 10 p.m. and 5 a.m. each day, unless you first receive written permission otherwise from the probation agent. In each file, you must not have any contact whatsoever with the victim, Stacy Cooker, nor must you be within 500 feet of her residence, school, or place of employment. In file 20-6518, you must serve 105 days in the Clare County Jail, but you will receive credit for 105 days served. In file 21-6663-FH, you must serve 73 days in the Clare County Jail, but you will receive credit for 73 days served. Those two jail sentences, as well as the probation sentences, will run concurrently to one another. They'll run at the same time. In each file, in file 20-6518-FH, you must comply with DNA testing and pay a $60 fee for that purpose. In each file, you must pay state costs of $68 for a total of $136 in state costs between the two files. In each file, you must pay a crime victims assessment of $130 for a total of $260 between the two files. In the 2020 file, you must pay a supervision fee of $540 to be assessed at the rate of $30 per month. You must pay a probation oversight fee in each file of $30 per month, and rising to $60 per month for any period that you are under electronic supervision. that will be assessed only in one of the files. So it will be a total of $30 per month or $60 per month between the two files. In each of the two files, you must pay court costs of $500 for a total of $1,000. In each of the two files, you must pay a fine of $500 for a total of $1,000. And in the two files, you must pay court-appointed attorney fees of, do you have an estimate, Mr. Dietrich?
I apologize, Your Honor, but I will have to submit those at a later date, please.
That's quite all right. For right now, we'll set attorney fees in the amount of $500 in each one of the two files for a total of $1,000, subject to amendment upon presentation of additional facts from Mr. Dietrich. That will be the sentence of the court in each one of these two files. The two sentences will run concurrently. They'll run at the same time. And in each of the two files, sir, it's my duty to inform you that you are entitled to appellate review of your convictions and sentences. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days in writing and sent directly to the court. Bond is canceled in the two files, and any bond that was posted in your own name will be applied towards court-ordered monies. That will be the sentences of the court. However, Agent McConnell might have some additional instructions to give to you. Do you have any such instructions, Agent McConnell?
I do, Your Honor. Thank you. Mr. Shook, since we have a longer court docket, if you get released from the jail today, prior to me coming and seeing you at the jail, you need to report to the courthouse immediately to have a GPS installed. You understand that?
Yes.
All right, today? Yes, if you get released today, prior to me coming and seeing you at the jail, you need to report to the Clare County Courthouse.
Okay.
Thank you very much, Your Honor.
Thank you, sir. Bond will be canceled. Any bond in either file that was posted in the defendant's own name will be applied towards court-ordered monies. The record should also reflect that the defendant received his copies of the advice of appellate rights form in each of the two files. He has signed the receipt forms acknowledging those facts, and the defendant remains in possession of his copies of the advice of appellate rights forms. Good luck to you, Mr. Shook.
Thank you.
You're welcome, sir. Good luck to you, sir. Calling the case of People versus Dakota Wind Johnson, file 21-6661-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Wetland, behalf of People.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Ms. Johnson. Was she able to be located by any chance?
No. Thank you, Mr. Dietrich. The record should reflect Dakota Johnson. The defendant was ordered to appear here in court for a pretrial conference to be held at 9:40 a.m. It's now 2.5 hours past that time, 3.5 hours.
Your Honor, I apologize.
Actually, 2.5. I apologize, sir. Do you know, it's now 12:14 PM by the court's clock. Do you know why Ms. Johnson has failed to appear, Mr. Dietrich?
Your Honor, it's my understanding that she's still incarcerated in Gladwin County. So I don't think she's not here by her own accord.
All right, then we will adjourn the pretrial conference in this case until the morning of Tuesday, September 7, 2021 at 9:40 a.m. The bond status will be continued. The case will be adjourned at date and time indicated. Thank you, Mr. Dietrich.
Thank you, Your Honor.
Is that the last of your cases, sir?
I believe so, Your Honor. Thank you.
Thank you, sir. Okay, thank you. Calling the case of People versus Nicholas Gray, file 21-6662-FH. Would counsel identify for the record, please?
Shona Dias, Mayor of People.
And attorney Tara Hovey appears on behalf of the defendant, Nicholas Dean Gray. Today is the date and time scheduled for a pretrial conference. In fact, it's about an hour and a half after the scheduled time. Thank you for your patience, Ms. Andrusaitis and Ms. Hovey and Mr. Gray. How did you want to proceed today, Ms. Hovey?
Your Honor, I have not received the updated paperwork from the prosecutor's office to proceed on a plea. So at this point, I think we'll have to handle this as a pretrial.
We did email those this morning to her out of our case tracking, so she should have Paula check her email for that documentation. But I do have the pretrial summary and the amended felony information for the court this morning.
Thank you.
I'm sorry, Judge, I've been on the waiting for the court, so I haven't had access to the email to review that. So unfortunately, due to the late sending that over upon my phone call, I would request a pretrial in this matter so that I could adequately prepare my client for the hearing.
Thank you, Ms. Hovey. That's a reasonable request. Very well. I assume you'd like the matter scheduled for a jury trial?
Please, Judge.
Thank you, ma'am. We'll schedule it for a jury trial for the moment, for a 2-day jury trial. And the matter will proceed to trial or to other disposition.
Your Honor, then I would ask for the amended felony information back. That was for purposes of plea.
Oh.
So Ms. Hovey, the amended felony information that you received via email today, that we spoke about on the phone weeks prior, that is not what we would proceed to trial on. It would be the original felony information. That amended was for purposes of plea today only.
That's sufficient. Unfortunately, when you email to someone that's not here, I don't necessarily have access to it, especially when I requested it to be emailed to me personally.
Thank you, ma'am. The case will proceed to trial or other disposition. The bond status will be continued. Thank you, Mr. Gray. Make sure you stay in touch with your lawyer.
All right.
Thank you, sir. Calling the two cases of People versus Timothy Lynn Lane, file numbers 19-6106-FH and 21-6106-FH. 6558-FH. Would counsel identify for the record, please?
Morning, Your Honor, Mark Webb on behalf of the people.
Morning, Your Honor, Karen Township, here on behalf of Mr. Lane.
And sir, are you Timothy Lynn Lane?
Yes, sir.
Mr. Lane, in file 19-6106-FH, you currently are on probation to this court in that file for the 10-year felony crime commonly known as possession of methamphetamine. Previously, you appeared in court, and at that time, you pled guilty to violating, actually, you pled not guilty to violating the terms of your probation. And you appear here today for a status conference in file 21-6558-FH. You appeared in court back on June 21, 2021, and at that time, you pled guilty to possession of methamphetamine. You appear here today to be sentenced. The maximum penalty the court can impose is 10 years in prison. The minimum sentence is discretionary with the court. And the Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, the departments calculate the applicable sentencing guideline range in that file to be 0 to 17 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Do you understand those things, Mr. Lane?
Yes, sir.
Ms. Tomchuk, have you gone over those two reports in that file, 2021 file with your client?
Yes, Your Honor.
Is there anything in either report of a factual nature that you want to add to or explain or contradict?
No, Your Honor.
And do you have any challenges to the scoring of the offense variables, the prior record variables, or the calculation as to the applicable guideline range being 0 to 17 months?
No, Your Honor.
And on behalf of the people, Mr. Webb, I pose that same series of questions to you.
Your Honor, thank you. I've reviewed the reports, have no additions or corrections to make to them. And the guidelines are correct.
Thank you, sir. Mr. Lane, is there anything, sir, you want to say on your own behalf before the court passes sentence on you in 2020?
No, sir. No, sir.
Thank you, sir. And on behalf of your client, Ms. Tomchuk?
Yes, Your Honor, it is that you follow the agreement in this case and not sentence Mr. Lane to any incarceration, continue him on probation. I would note to the court that he does have a closed head injury. He has a very difficult time in the jail based on some medical needs that he does have. And I think that Mr. Lane can be successful on probation. This is another one of those cases where, you know, people were doing successful on probation while they were being monitored, and then the pandemic hit, which severely limited the monitoring and caused, I would say, not only Mr. Lane, but multiple other of my clients to slip back into some old habits. I think we can get him back on the right track, Your Honor.
Thank you, ma'am. And on behalf of the people, Mr. Webb?
I ask you to follow the plea agreement and recommendations from the probation department.
Thank you, sir. Very well, Mr. Lane, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court. You'll be committed to the you'll be placed on probation for a period of 2 years. And you must follow all the terms of your probation order and all the statutory terms of the probation order as well. all the written terms and statutory terms, including but not limited to, you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to drug and alcohol testing on demand, and you must successfully complete any substance abuse treatment program to which you are referred by the probation agent. You must not and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must not have any contact with anyone who you know to have a felony record. You must not use or possess any weapons or copies of weapons. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must submit to a search of your person and property without the search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. You must pay $68 in state costs and a crime victims assessment of $130. You must pay a supervision fee of $30 per month, rising to $60 per month for any period that you are on electronic supervision. You must pay court costs of $500 and a fine of $500 and court-appointed attorney fees of, do you have an estimate, Ms. Tomczyk?
It'd be $1,330.
Court-appointed attorney fees of $1,330. All to be paid while you are on probation, but it must be paid off by the time you get off of probation. So you must pay at least $150 per month, with each payment being due by 12 noon on the first day of each month, starting on September 1 of 2021, with an additional $150 payment due by 12 noon on the first day of each month thereafter, until paid in full, but it all must be paid before you get off of probation.
Your Honor,
Yes, ma'am.
Mr. Lane is on disability. He does not receive that payment until the 3rd, so I'm wondering if we could make his payment date the 5th of each month.
Yes, ma'am. Thank you for bringing that to my attention. Each payment will be due by 12 noon on the 5th day of each month, starting on September 5th. Thank you, ma'am. Turning to file 19-6106-FH. In that file, is it correct, Ms. Tomczyk, that the defendant has not yet pled guilty to violating his probation?
Your Honor, I don't see any notes indicating that he did plead. I'm wondering why we didn't take a plea on the same day. I don't know if this was just a matter of it wasn't, it may have been a final pretrial, Your Honor. We didn't have the probation file.
Thank you, ma'am. Does the defendant stipulate that the court may revoke his 7411 status in that file? Or does he want to go through with the plea taking process in that file?
Your Honor, I think based on the fact that the court could take judicial notice of the plea that was entered and that being a violation of probation, then yes, the court could, in its discretion at that point, withdraw the 7411 status.
Very well. In that file, the 2019 file, the court does terminate the defendant's 7411 status and enters the conviction for possession of methamphetamine on his record. you want to proceed directly to sentencing in that matter, Ms. Tomczyk?
Your Honor, I have no objection to proceed with sentencing.
Very well, Mr. Lane, in file 19-6106-FH, your probation, your 7411 status has been revoked, and the court will be proceeding to sentence you for the underlying conviction of possession of methamphetamine. The applicable sentencing guideline range is 0 to 6 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Is there anything, sir, you want to say on your own behalf before the court passes sentence?
No, sir.
Lane?
No, sir.
Thank you. And on behalf of your client, Ms. Tomczyk?
Your Honor, I would reiterate what I had previously said during this case. Your Honor, I'd ask that the court continue Mr. Lane on probation. He has been compliant throughout the pendency of this case that has been going on for the original case, or the new case, I guess, has been going on for quite some time. So I think we've got him back on track, Your Honor, and the fact that he now has 2 convictions for possession of methamphetamine is very much punishment, Your Honor. And so again, I would ask that the court continue Mr. Lane on a formal probation without the 7411 status under the convictions.
Thank you, ma'am. In that file 19-6106-FH, the probation department prepared a report dated August 4th, 2020, but then updated July 26th of 2021. Have you reviewed that updated report with your client?
Yes, Your Honor.
Is there anything in that report, the updated report, of a factual nature you want to add to or explain or contradict?
No, Your Honor.
And on behalf of the department, Mr. Webb, do you have any additions, corrections, or deletions you want made to the updated probation violation report?
No, thank you, Your Honor.
Thank you. Mr. Lane, is there anything further you'd like to say regarding sentencing?
No, sir.
And on behalf of your client, Ms. Tomczyk?
Again, I'll take the court's time, Your Honor, but we would ask that the court consider the entrance of the felony conviction on Mr. Lane's record of punishment and continue him on probation.
Thank you, ma'am. Very well, then, the 7411 status is set aside. The conviction for the 10-year felony is entered on the defendant's record. As far as sentencing, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you a chance to rehabilitate yourself, you'll be continued on probation for a period of 2 years from today's date. All the original terms of your probation order will remain in effect, including that you must pay all the fines and costs and fees previously allotted and ordered. Do you have any additional court-appointed attorney fee to be assessed, Ms. Tomczyk?
Your Honor, I'm trying to figure that out right now.
Thank you.
$410, Your Honor.
You must pay additional court-appointed attorney fees of $410, Mr. Lane. Finally, your driver's license will be suspended or revoked pursuant to Michigan Compiled Law 333.7408A. Now, sir, it's my duty to inform you with regard to each of these 2 sentences in these 2 separate files that you are entitled to appellate review of your convictions and sentences. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But A request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Please sign the receipt form in each file, which is your acknowledgement that you received your copy of the advice of appellate rights form in each file. The record should reflect that the defendant has received his copy of the advice of appellate rights form in each file. He has signed the receipt form in each file, and the 2 receipt forms have been returned to the court clerk. Bond is canceled in each file, and any bond posted in the defendant's own name will be applied towards court-ordered monies. Sir, that finishes my sentencing of you. However, Agent McConnell from the probation department might have some additional instructions to give to you. Agent McConnell.
Thank you, Your Honor. Mr. Lane, we'll just continue with your normal report date this Friday at the courthouse as usual.
Okay.
All right, then nothing further, Your Honor. Thank you.
Thank you, Agent McConnell. Thank you, sir. Thank you, Mr. Lane, and good luck to you. Mr. Moore?
Yes, Your
Are you ready on your cases?
I believe we are. Your Honor.
Is that so?
You're gonna soldier up, right?
Until I call. Thank you. But thank you, sir.
You're welcome.
Do you have a preference as to what?
Mr. Williams is here. We have 3 other matters with people who are lodged. Tigner, Feltner, and Richard.
Okay, thank you. Calling the case then of People versus Roger Allen Williams Jr. File 21-6560-FH. Would counsel identify for the record, please?
Sean Mazias, People.
Please, the court, Scott Moore for the defense.
And sir, are you Roger Allen Williams Jr.?
Yes, sir.
Today is the date and time scheduled for a final pretrial conference on this matter. How are we proceeding, Mr. Moore?
Your Honor, the prosecution has tendered a new pretrial summary. We would be proceeding on count 1, aggravated stalking. The habitual offender notice will be dismissed.
Would this be a guilty plea?
Yes, Your Honor.
Mr. Williams, would you please raise your right hand and be sworn, sir?
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Could you tell us your name, sir?
Roger Allen Williams Jr.
Mr. Williams, do you understand, sir, that according to count 1, actually the only count in the file, that you are charged with the crime commonly known as aggravated stalking?
Yes.
Now, that crime is a felony that carries a maximum penalty of 5 years in prison and/or a fine of up to $10,000. And further, if you are placed on probation, it must be for a term of 5 years. Do you understand those things, sir?
That's if the delay doesn't. That's true. Yes.
Now, with regard to aggravated stalking, which with the people's permission, I'm going to, and the defensive permission, I'm going to amend the information on the record by adding the designation count one. Do you have any objection, Ms. Ambrositis
No.
or Mr. Moore?
Aye.
Very well, the court has amended the information on the record to designate count one as being stalking aggravated. Mr. Williams, do you understand, with regard to count one, you may make any of the following three pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas you may make to count one, aggravated stalking?
Yes,
And answering to count one, aggravated stalking, what is your plea?
guilty.
Sir, do you understand that no one can make any promises for me about what your sentence will be? The court, I'll ask you to speak up a little louder. Do you understand those things, sir?
Yes, sir.
The court also informs you that if your plea of guilty is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you, but on the other hand, you also have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Williams?
Yes, sir.
And do you understand that by pleading guilty to count one, aggravated stalking, that means you'll be giving up each and every one of those rights?
Yes, sir.
Now, sir, I'm going to ask your lawyer and the elected prosecuting attorney, Ms. Ambrositis, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Ms. Ambrositis, what is the plea agreement?
Your Honor, in terms of the defendant's guilty plea to the aggravated stalking count, the people would agree to pursue diversion Killebrew to a delay of sentence for 12 months. If the defendant successfully completes that delay of sentence, it would be reduced to a domestic violence misdemeanor count. We would dismiss the habitual second upon sentencing and running the appropriate appeals period. Additionally, the following files will be dismissed pursuant to this plea: 21-2590 SM, 20-0928 SM, 20-0762 SM, and 20-0539 ST. We will also not authorize charges in CCSD Incident Report 21-186-4. There is also an agreement that there would be no initial incarceration, but that obviously comes with a 12-month delay. Inherently, restitution is to be determined to the victim. Defendant is to participate in all DHHS recommended services and any requirements in the probate court guardianship. He is to continue substance abuse testing and counseling. Thank you.
Mr. Moore, is that your full and complete understanding of the plea agreement? Mr. Williams, did you hear what your lawyer and prosecutor said the plea agreement is?
Yes, sir.
Did you understand the plea agreement?
Yes, sir.
And do you agree with it, sir?
Yes, sir.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No, No, sir.
So for example, has anyone promised you that if you plead guilty, this court then would be lenient or light on you in any way?
No, sir.
Do you have any questions about what the court has told you?
No, sir.
Do you understand everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty to count 1, aggravated stalking?
Yes, sir.
Then, sir, drawing your attention back to December 11, 2020, were you in Garfield Township in Clare County, Michigan?
Yes, sir.
On that day and at that location, did you engage in a willful course of conduct involving repeated harassment of Shiloh Della Schmidt?
Yes.
And would that conduct have made a reasonable person feel frightened or harassed or intimidated or molested or terrorized or threatened?
Yes.
And is that how that conduct did make Shiloh Della Schmidt feel?
Yes.
And in addition, back before December 11, 2020, had a court here in Michigan issued a personal protection order against you in file 20-900428-PP, which required you to refrain from doing certain things with regard to Shiloh Della Schmidt.
Yes.
And were some of the things that you did involving Shiloh Della Schmidt back on December 11, 2020, were some of those actions a violation of that personal protection order?
Yes, sir.
Mr. Moore, are you satisfied that there's a sufficient factual basis to accept the defendant's plea of guilty to count 1 aggravated stalking?
Yes, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Mr. Moore, has the court complied with the court rule in the taking of this plea?
Yes, Your Honor.
Do you agree, Ms. Ambrositis?
Yes.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor or the defendant or defense attorney or anyone else. The court is convinced that the plea is accurate, has been understandingly, knowingly, and voluntarily made. Plea of guilty to count 1 is accepted and ordered entered on the records of the court. Sentencing will occur at 9 a.m. on Tuesday, September 7, 2021. The bond status is continued and the case is adjourned to the date and time set for sentencing. Now, sir, when you come back on that day, you could be sent to prison, or you could be put in the county jail, or something else might happen. The one thing that will happen is you'll be ordered to pay some court-ordered money that will add up to probably $2,200 or $2,300. You now have another 5 weeks or so to take legal steps to raise that money and have it available to you at the time of sentencing. That will conclude the plea taking process as far as the court is concerned. However, Agent McConnell from the probation department might have some additional instructions to give to you. Agent McConnell.
Thank you, Your Honor. Mr. Williams, since you appeared in person, come down to the probation department. When you come down to the bottom of the stairs, take a left, go all the way down to the hallway and go to the open door and see our clerical staff, and they will provide you with the paperwork for your PSI.
Okay.
Thank you very much, Your Honor. Nothing further.
work.
Thank you, sir.
Thanks, Evan. Day after the telephone. He is no longer with us, and he was dropped by it.
Mr. Moore,
Yes, sir.
do we need the presence of your clients in the Tigner Health case? Or
I think given the nature of the conflicts. So, unless you want to see the Terry.
Well,
Mr. Reed, we do have to take care of it.
okay, recalling the case of People versus Jeremy Robert Tigner, file 21-6693-FC. Attorney Scott Moore appears on behalf of the defendant, appearing on behalf of the people.
Show everybody.
Thank you, ma'am. Mr. Moore, do you have a motion you wish to make in that time?
I do, Your Honor, thank you. This motion follows brief colloquy in chambers with Assistant Prosecuting Attorney present. As regards Mr. Tigner's case, I have represented Mr. Tigner in the past and was consequently assigned to represent him on those probation violation matters as well as the current pending felony charges. During the course of my investigation, I identified the presence at the scene of the alleged crime of one Roger Williams. At the time, I did not see that there was an actual conflict of interest. But Mr. Tigner was aware of that and he had misgivings. Based on conversations that I had with Roger Williams, a client to whom I was appointed to represent before this current spate of charges against Mr. Tigner, it has become clear to me that the interest of one client would be adverse to another. But it only works in one direction. Nothing that Mr. Tigner has to say or shared with me about Mr. Williams, if at all, has any bearing on the case that's still pending. So I believe that my representation of Williams is viable. My representation of Tigner is not, because of an actual conflict of interest that cannot be resolved nor can it be waived.
And so as a consequence, you are.
Oh, I didn't get around to the prayer for relief, did I? Your Honor, wherefore, if it please the court, I'm asking to be withdrawn as attorney of record on Mr. Tigner's behalf of all of his clients.
It's your understanding Mr. Tigner shares your concerns.
He identified it to me, and in light of what I heard from Mr. Williams this morning, it confirmed his concerns that I can no longer represent his interest.
Very well, then the court will relieve you of your obligation to Jeremy Robert Tigner and remove you as his court-appointed attorney. The court will appoint a different attorney to represent Mr. Tigner, and you will ask that that case be scheduled for a status conference sometime in September. Thank you, Mr. Moore.
Thank you.
And then calling the two cases of People versus Kane that comes Felton, file 20-6459-FH and 21-6687-FH. You have a motion to file in those two matters, Mr. Moore?
Your Honor, if it please the court, I will make this motion orally on Mr. Felter's case. During the course of my representation of one Jeremy Tigner, I was assigned to successor counsel on Mr. Felter's case, and I believe that was Mr. White who sent those over. I had not received the paper file that revealed statements made by client Tigner adverse to King Felton. And although I no longer represent Mr. Tigner, based on the information that I received from his side of it, I do not believe I could adequately represent Mr. Feltner in his action. I believe I would be called upon to cross-examine Tigner, should that matter proceed to preliminary examination or trial or some other hearing. I no longer represent Tigner, but with the knowledge that I have, I cannot as easily vanish. And so again, as in Mr. Tigner's case, I respectfully request the court remove me as the attorney of record of Mr. Feltner, extend my apologies to him for not identifying this obvious conflict earlier, and appoint successor counsel to me.
Do you have any position in this matter, Ms. Ambrositis?
We do not.
Very well, the court will grant the request and remove Mr. Moore as the attorney of record for Mr. Feltner, with the thanks of the court with regard to each of these two files. And the court will appoint a successor counsel in each of the two files. Thank you, Mr. Moore.
Thank you. May I approach briefly?
Sure. And regarding Mr. Reed,
I probably should take the opportunity to speak to Mr. Webb unless he has a case coming up with this township. He does. Well,
thank you.
I'm local. There's no. Is he up? I read. No. Okay.
Yes. Look out, see if they can see him.
Calling the cases of People versus Brett Allen Wish, file 18-6051-FH and file 21-6695-FH. Will counsel identify for the record, please?
Sherman's Ice Cream, you have people.
Hey, Your Honor, Karen Tomchak appearing on behalf of Mr. Risch, I believe formally in 21-6695FH. I don't know, I made, Mr. Risch had asked for appointed counsel in the district court. He had wrote both case numbers on there. And in speaking with him, he would like me to be appointed officially on the probation violation, Your Honor.
Okay, without objection, then the court will appoint you to represent him in file 18-6051-FH as well. The defendant appears here in the 2021 case to be arraigned. How do you want to proceed regarding arraignment, Ms. Tomchak?
Your Honor, we would waive reading, ask that court enter a pleas of not guilty, but allow us to address bond, Your Honor.
Very well, pleas of not guilty will be entered on behalf of the defendant in the 2021 case. What is your request regarding bond in that matter, Ms. Tomchak?
Your Honor, I'd actually ask the court, Mr. Risch has been in contact with a gym from Sunrise Center in Traverse City. He is looking and seeking treatment, Your Honor. He was supposed to call them yesterday because he thought he was going to have court. Obviously, at no fault to Mr. Risch, we did not have that. So we would ask that the court, if upon presentation of that Mr. Risch has a bed, amend to a personal recognizance bond to allow him to attend the treatment.
Mr. Webb, do you have any objection to that request or not?
Your Honor, I appeared on behalf of Mr. Webb, who is not in the courtroom at the time. I have no objection with that as long as the PR bond stipulates that when he completes treatment, he is to return to jail unless we otherwise determined that that would not be in his best interest and he is to be tested upon return to the jail.
Thank you, ma'am. And is that acceptable to you, Ms. Township?
That is, Your Honor.
All right, will you be preparing an order to that effect or not?
I will prepare that order, Your Honor.
Thank you, Ms. Township. That's on the 2021 case, then with regard to the 2018 case filed 18-6051-FH. In that matter, the defendant was scheduled for a status conference to be held today regarding the pending probation violation charges. Is there anything you wanted to address in that file, Ms. Township?
Your Honor, I would again ask that the bond be amended to reflect the new bond that we had set in the original case that allows him a personal recognizance bond to go to treatment.
Any objection, Ms. Anderson?
No.
Very well, then the court will so order and will ask you to prepare the proposed stipulation and amended bond order in this township.
Your Honor, if I may.
Sure, Mr. McConnell.
My apologies, Your Honor. Ms. Tomczyk, I just want to clarify, you said Sunrise in Traverse City. Is that Traverse City or is that the Sunrise Center in Alpena?
He indicated the number that he had said it was in Traverse City, but I have indicated to Mr. Risch to have him sign a release to myself, and that I can provide exactly where the bed is on the order.
Okay, very well. Thank you.
Thank you, Mr. McConnell. Good luck to you, sir. The bond status will be continued until the Monday.
Thanks, sir.
Thank you. Calling the case of People versus Marcus Mitchell Bay, 521-6678-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Good afternoon, Your Honor. Karen Tomczyk on behalf of Mr. Bailey.
And today's the date and time scheduled for an arraignment in this matter. How did you want to proceed, Ms. Township?
Your Honor, we do have a plea agreement worked out, and Mr. Bailey would still like to take advantage of that.
Very well. And to what counts would this be a plea to?
He is pleading to count 1 without the second or subsequent offense notice, and count 2, Your Honor.
Thank you, ma'am. Mr. Bailey, would you please raise your right hand and be sworn, sir?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you tell us your name, sir?
That's Mr. Bailey, second.
Mr. Webb has had the people file an amended quote information in this matter, or do you want me to amend the information on the record instead?
We haven't, Your Honor, or I haven't, Your Honor. This was set for arraignment today, so I didn't know it was going to be a plea, so I'd ask you to do it from your bench.
Thank you, sir. And the court then at the request, do you have any objection to that request, Ms. Township?
No, Your Honor.
Very well, then the court will amend the information on the record by striking the second or subsequent offense double penalty portion as it pertains to count 1. And Mr. Bailey, do you understand, sir, that according to count 1 of the information as amended on the record here today, that you are charged with the 10-year felony crime of possession of methamphetamine?
Yes, Your Honor.
Now, that crime is a felony and it carries a maximum penalty of 10 years in prison and/or a fine of up to $15,000. The minimum sentence would be discretionary with the court. However, unless the court sentences you to more than 1 year in prison, then the court must impose driver license sanctions pursuant to Michigan Compiled Law 333.7408A. Do you understand those things?
Yes, Your Honor.
You understand, sir, that in the information, you also are charged in count 2 with domestic violence first offense.
Yes, Your Honor.
Now, that crime is a misdemeanor, and it carries a maximum penalty of 93 days in the county jail and/or a fine of up to $500. Do you understand those things?
Yes, Your Honor.
Now, with regard to count 1 as amended here on the record, and also with regard to count 2, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 1 and count 2, sir?
Yes, Your Honor.
And answering to count 1, possession of methamphetamine, what is your plea?
It's guilty, Your Honor.
Answering to count 2, domestic violence first offense, what is your plea?
It's guilty, Your Honor.
Now, sir, do you understand that no one can make any promises for me about what your sentences will be?
Yes, Your Honor.
The court also informs you that if your pleas of guilty are accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But on the other hand, you also do have the right to testify at the trial, and if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of those rights, sir?
Yes, Your Honor.
And do you understand that by pleading guilty to count 1 as amended on the record and to count 2, that means you'll be giving up each and every one of those rights?
Yes, Your
Now, I'm going to ask your lawyer, Ms. Township, and the assistant prosecuting attorney, Mr. Webb, to tell us what the plea agreement is. I want you to listen to both of them very carefully. Mr. Webb, what is the plea agreement, sir?
Thank you, Your Honor. It's my understanding the defendant will be pleading guilty to count 1, possession of methamphetamine, and to count 2, the domestic violence. I will file an amended information that does not contain the second or subsequent offense notice. As a sentencing recommendation as to count 1, I'll recommend a 1-year delay. If the defendant is successful, that can be reduced to the 1-year misdemeanor use of methamphetamine. And there is no sentence agreement as to the domestic violence conviction, count 2. And if there's any restitution, that's to be determined.
Thank you, sir. Ms. Tomczyk, is that your full and complete understanding of the plea agreement?
Your Honor, my understanding is that it would be an agreement to the delay, not simply a recommendation.
That's correct.
Okay.
With that clarification, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Bailey, did you hear what the assistant prosecutor said? The agreement is? Do you understand the plea agreement?
Yes.
Do you agree with that plea agreement?
Yes, sir.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty to count 1 and count 2?
No.
So for example, has anyone promised you that if you plead guilty, that this court then would be lenient or light on you in any way?
No.
Has anyone threatened you or your family to get you to plead guilty?
No.
Is it your own personal choice to plead guilty? And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Do you understand everything that the court has told you?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
And drawing your attention back to April 7 of 2021, were you in Clare County, Michigan?
Yes.
On that day and at that location, did you have some methamphetamine in your possession?
Yes, Your Honor.
At the point in time when you had that methamphetamine in your possession, did you know that it was methamphetamine?
Yes, Your Honor.
Did you have any legal right or justification or mitigation permitting you to possess the methamphetamine?
No, Your Honor.
On that same day and at that same location, did you commit an assault or battery upon
Yes, Your Honor.
And Amy Lee Edwards, was she a woman that you were dating at that time?
Yes, Your Honor.
And what did you do regarding Amy Lee Edwards that brings you into court here today? For example, did you hit her, push her,
I
or
just pushed
grab
her,
her
Your Honor.
against her will?
I just pushed her, Your Honor.
And did you do that against Amy's will?
Yes, Your Honor.
Were you acting out of anger at the point in time when you pushed her?
Yes, Your Honor.
You were not acting out of self-defense, for example, were you? Ms. Tomczyk, are you satisfied there's a sufficient factual basis to accept each of these two pleas?
I am, Your Honor.
Mr. Webb, do you agree?
Yes, Your Honor.
Ms. Tomczyk, has the court complied with the court rule in the taking of these two pleas?
It has, Your Honor.
You agree, Mr. Webb?
You have, Your Honor.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentences with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the pleas are accurate, have been understandingly, knowingly, and voluntarily made. The pleas of guilty are accepted and ordered entered on the records of the court. Sentencing will occur on Tuesday, September 7 at
10 a.m., Your Honor.
at 10 a.m. Thank you, Ms. Tomczyk.
Your Honor, if we could address bond, Mr. Bailey would be asking for a personal recognizance bond in light of the plea agreement in which Mr. Bailey is getting a delayed sentence, which there would be no additional incarceration. I would note to the court that I believe Mr. Bailey has done approximately 2 months at this point in time. And so based on that circumstance, we would, again, like a personal recognizance bond.
Do you have any objection, Mr. Webb?
I'll leave that to your discretion, Your Honor, and if you do determine to do that, I would ask that the original conditions of, the other conditions of bond remain in effect as far as the victim of the domestic violence, any drug testing, and other requirements like that.
Anything further, Ms. Tomczyk?
No, Your Honor.
Very well, the court will reduce the bond to a personal recognizance bond in the amount of $5,000. All the other original terms and conditions of the bond will remain in effect, including but not limited to no contact with the defendant, with the victim Amy, as well as the drug testing regime would remain in effect. That will be the order of the court, and with regard to the plea, that concludes the plea taking part of this court. However, the probation agent, Mr. McConnell, might have some additional instructions to give to you. Mr. McConnell?
Thank you, Your Honor. Mr. Bailey, when you are released from jail, where do you plan to reside at?
It's 2714 Margaret Street.
Okay, and what do you know what your phone number is?
It was 99-588-1109. I think it's gonna be 99-931-0149. And if that ain't exactly right, because I don't remember the number, I can call and let her know, or you know also when I get out, because I got a card in my wallet to put time on my phone as soon as I leave.
Okay, I will be over to bring your PSI packet with instructions prior to you being discharged from the jail.
Okay, thank you, sir.
And Your Honor,
Thank you, Your Honor.
I would ask that actually probation send me that packet. I will get a hold of Mr. Bailey and fill that packet out, get back with probation and set an appointment that I can attend.
Very well. Ms. Tomczyk, can you stop down and get that packet then before you leave?
Not a problem.
Awesome. Thank you. Thank you, Your Honor. Nothing further.
Thank you, Agent McConnell. Thank you, Ms. Tomczyk.
Thank you, Your Honor.
Does that conclude your cases, Ms. Tomczyk?
Your Honor, we have probation violation with Nico Wright.
Calling the case of People versus Nico Henry Wright, file 20-6397-FH with counsel identified for the record, please.
Thank you, Your Honor. Karen Tomczyk on behalf of Mr. Wright.
How did you want to proceed today, Ms. Tomczyk?
Your Honor, I'd be asking for an adjournment in this case. There's an underlying felony matter that has yet to be resolved. I actually just received the discovery on that case yesterday. We conducted a probable cause conference. In this case, I do know Mr. Wright would be asking for a reduction in his bond. He indicates to me that he would need a personal recognizance bond. I would note to the court, I represented Mr. Wright on the underlying felony case. I never had a problem getting a hold of him. He was in contact with my office. To the best of my knowledge, he never failed to appear for court. I don't see any violations that indicate that he had failed to report to probation, Your Honor.
All right, well, taking matters one step at a time, the request to adjourn today's proceeding is granted, and do you expect the felony matter to take some period before it's resolved?
Your Honor, it's set for a preliminary examination next week. That is still at this point in time set to run, so that will either run or it will be waived up with a resolution. So I would suggest that if the court would set this sometime beginning September. I don't know if the court has any further motion days in August.
Okay, we'll schedule the case for a status conference at 10 a.m. on Monday, September 20th, 2021. With regard to the request to reduce this bond to a personal recognizance bond, Agent McConnell, does the department have any position with regard to that request?
Your Honor, in speaking to Agent Medley prior to the hearings today, she's going to be recommending a 12-month jail sentence and unsuccessful discharge. It would be our position that bond remain the same and that he be lodged in the county jail until the probation violation has been taken care of.
Great. Anything further on behalf of the people?
Yes, Your Honor, his pending felony is another drug charge as a habitual third offender. I would ask that his bond remain the same.
All right.
Your Honor,
Further this time, Chip?
if the court will not do a personal recognizance bond, if it could even add a surety, I see at this point it's just a cash bond.
Thank you, ma'am. Very well. The court will continue the bond as previously set. That appears to be appropriate to the court. Thank you for being here, sir, and the case will proceed to a status conference on September 28th. Ms. Hovey, do you you want me to follow the rate case?
No, Your Honor, that's actually already been rescheduled by your schedule clerk for tomorrow. Judge, if I may, I wanted to approach you with regard to a schedule issue with regard, and I needed Ms. Ambrositis and Mr. Left to be present for that as well. You have a moment, so I'm willing to wait until you have time, Judge.
Okay, thank you, ma'am.
Sure.
Calling the cases of People versus Stephanie Renee Johnson, file 21-6609-FH, and People versus Jeffrey Lee Miracle, file 21-6624-FH, and file in those two files, neither Attorney Rowe nor the defendants have appeared today, which is highly unusual for Mr. Rowe. I don't know if matters were rescheduled from yesterday to today, but in any event, with regard to those two cases, the court will adjourn those matters to September 20th. 2021, the bond status in each case will be continued. Calling the case of the people of the state of Michigan versus one male neutered black and white pit bull, ACO ID number 233D20, file number 21-900191-CF, would counsel identify for the record, please?
Terms asking how many people.
Does anyone appear in that matter? Specifically, does Britton Jemison appear, or anyone on behalf of Britton Jemison? The record should indicate no response. The record should further indicate this matter originally was scheduled to be heard on Monday, August 2nd, 2021. It then apparently was rescheduled to today's date. At 1:30. It's not yet 1:30. The court will wait until 1:30 then, and I apologize, Ms. Ambrositis, for jumping the gun on you.
Your Honor, we're finished with this morning's hearings?
Unfortunately, Mr. Moore is meeting with his clients, but let's take a break and we'll be in recess on those matters and then decide how to proceed a little bit later. Pit bull, file 21-900191-CF, record reflect elected prosecuting attorney Michelle Ambrositis appears on behalf of the people. This matter was scheduled for a hearing on the people's motion for default judgment in an animal forfeiture matter. It was scheduled to be heard at 1:30 PM today. It's now 2:05 PM by the court's clock, 35 minutes past the scheduled time. The claimant, Britton Jemison, has failed to appear. And the people have prayed for the relief that this court issue an order of forfeiture of the claimant's property and the bond posted be disposed of as provided by law, as award costs to the plaintiff as provided by statute. How did you want to proceed, Ms. Ambrositis?
Your Honor, we would stand on our pleadings that are filed, and we would ask the court to order that the white pit bull ACOID 233D20 be forfeited, that the prosecutor's office be awarded $36.44 in fees associated with the service process in this case, and that we be awarded expenses to pay the cost of the care, housing, and veterinary medical care for the animal as applicable, and that would be ordered to be paid directly to their county animal control. I see that Ms. Hicks is here, but I don't know if they know on the top of the head what those total expenses would be. Oh, she has it. She is prepared today. I prepared with its handwritten
Thank you,
because
Ms.
I
Ambrositis.
were done today. So, excuse my. We would ask that they be awarded, the Clare County Animal Control be awarded a total of $3,820. That would cover 378 days at $10 per day, and flea treatment and vaccines at $40. And that's as of August 2nd, 2021, and we will cap that request at that amount. So that's what we asked for, Your Honor. Thank you.
Very well, so ordered. The court will grant the relief as requested. The record should reflect it's now 2:08 PM by the court's clock, 38 minutes past the scheduled time for this hearing. The claimant, Britton Jemison, has failed to appear either in person or via Zoom, and that will be the order of the court. The court will grant the forfeiture as requested. Thank you, Ms. Ambrositis.
Thank you, Your Honor. We'll prepare an order.
Thank you, ma'am.
Thank you.
So, oh, I'm sorry, Mr. Lawyer, I didn't realize you were here, so. We've dealt with most of your cases.
My docket with you is concluded.
Oh,
I have a matter which I should make.
Oh.
It's scheduled for 3:30, but we might be able to get it early. We're on this.
okay, thank you. And we still have some,
We have a 2:30 and a 3.
but have we finished with the running matters? Oh, yeah. Well, bless you. Thank you, Michelle.
Thank you, Judge.
All right.
We'll be in recess.
Jones Ice Cream and People.
Where's the court's go?
You are Jonathan William Matthews. Yes, sir. How old are you? 42. You raise your right hand and be sworn.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I believe you count 1 and 2 with a visual second, is that correct?
No, eventually.
No, visual, just counts 1 and 2.
Yes, sir.
All right. Mr. Mackey, you've seen the information and gone over that information with your attorney, is that correct? Yes, sir. And Mr. Or is he waiving reading of the information for today?
Yes, sir.
And previously, he waived preliminary examination?
Yeah, Your Honor. Thank you. And we continue that way.
Mr. Mr. Mackey, you've been charged with count 1, tampering with electronic monitoring device. That's a felony. It carries a maximum penalty of 2 years in prison and or a $4,000 fine. And you're charged with count 2, tampering with electronic monitoring device. Felony, it carries a maximum penalty of 2 years in prison and or a $4,000 fine is the maximum. The minimums are discretionary with the court. You understand the charges and the possible penalties? Yes. There's one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you make? Yes. Answering to count 1, tampering with electronic monitoring device, how do you plead? Guilty. Answering to count 2, tampering with electronic monitoring device, how do you plead? Guilty. You understand that no one may make any promises for this court as to what your sentence will be? Yes. The court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights? Yes. You understand by pleading guilty, you give up each and every one of those rights? Yes. Ms. Ambrositis, what is the plea agreement?
In return for the defendant's guilty plea as charged, the people would move to dismiss the eventual under notification upon sentencing running the appropriate appeals period. There is also an agreement that there would be no initial incarceration. This is pursuant to Briggs and Killebrew. And we do recognize that that is below guidelines. And we further agree that we will sign the PR bond stipulation once it is presented by Mr. Moore to our office. Thank you.
Mr. Moore, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Mackey, did you hear what was put on the record as a plea agreement?
Yes, sir.
Did you understand it?
Yes.
And are you in agreement with it?
Yes.
Has anybody promised you anything beyond what was placed in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty? I didn't hear an answer. Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No.
Is it your own personal choice to plead guilty?
Yes.
And are you doing so freely and voluntarily?
Yes.
Do you have any questions about what the court has told you?
Yes, sir.
Have you understood everything that the court has told you?
Yes.
In light of everything the court has told you, do you still wish to plead guilty?
Yes.
Drawing your attention to on or about March 27th of 2021, were you in Hayes Township, Clare County, Michigan?
Yes.
And were you on parole at that time?
Yes.
And did they put electronic monitoring device upon you?
Yes.
And did you knowingly interfere with the signal, the impulse or data being transmitted or stored by the electronic monitoring device?
Yes.
And I guess how did you do that?
I'm not sure the exact dates, but one of them I had 2 tethers on. One of them was an alcohol tether I was plugged in, I placed it in the refrigerator. The other one I didn't charge was a GPS tether.
So you interfered with both of them?
Yes.
Satisfied with the factual basis, Ms. Ambrositis?
Yes.
Satisfied with the factual basis, Mr. Moore?
Yes, Your Honor.
Has the court complied with court rules, Ms. Ambrositis?
Yes.
Has the court complied with the court rules, Mr. Moore?
Yes, Your Honor.
The court has not agreed upon the possible plea or the possible sentence with either the prosecutor, the defendant, or anyone acting in the interest of either. The court is convinced the plea is accurate, has been freely, voluntarily, understandingly, and knowingly made. The plea is accepted in order that upon the records of this court. Sentencing will be set for September 27th at 8:45 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. The court will sign the stipulation for the reduction in bond. on presentation. If you bound out before they get any information, they're gonna drop off a PSI packet at the jail, and then you gotta contact the number that's on there to make sure you get an interview done. Anything else you wish to say, Mr. McConnell?
No, thank you, Your Honor. Thank you.
Anything further from either party?
No, thank you.
Okay, thank you very much.
All right, we're in recess.
All rise. The 55th Circuit Court is now in session with the Honorable Thomas R. Evans presiding.
Good afternoon, you may be seated. Calling the case of Renee Lynn Graff versus Timmy Douglas Silman, file 18-900224-PP. Would counsel identify for the record, please?
Thank you, Your Honor. Todd Diedrich on behalf of the respondent and petitioner at this point, Timmy Douglas Silman.
And does Renee Lynn Graff appear in this matter? Or does anyone appear on her behalf? The record should indicate no response. The record should further indicate that back on January 26, 2021, or actually January 27, 2021, the respondent, Tim Silman, filed a motion to terminate the personal protection order in this matter. The court on April 8, 2021, signed an order to authorize alternate service to be effectuated on the petitioner. According to a proof of mailing in the file, a notice of hearing was served on the petitioner. And then subsequently, the case was scheduled to be heard today at 2:30 p.m. It's now half an hour past that time. It's 3 p.m. by the court's clock. The petitioner has failed to appear. This all relates back to a personal protection order that the court issued an ex parte personal protection order that the court issued on May 16 of 2018, set to expire on May 16 of 2023. The petitioner has failed to appear today. Do you still want the personal protection order to be terminated, Mr. Dietrich?
Yes, Your Honor, that is the request.
Thank you, sir. The burden is on the petitioner to show cause why the personal protection order should remain in effect. The petitioner has failed to appear. It's now 3:02 p.m. by the court's clock. The court will grant the motion to terminate the personal protection order, and Thank you. And Mr. Dietrich, the court will sign an order to that effect, and the court will prepare its own order.
Thank you very much, Your Honor. The clerks could just put a copy in my basket. I'll have someone pick it up. Thank you very much.
Will do.
Thank you, sir, and thank you, Mary. We'll be in recess then.
All right, thank you, Your Honor.
Thank you, sir.
I do have Mr. Post. I will read for the 3:00 hearing.
Thank you. Has anyone else appeared on that case?
No.
Calling the case of Donna Cyphers versus Kenneth Goff, file 20-900462-CH. Would counsel identify for the record, please?
Your Honor, Isaac Post for the plaintiff.
Does anyone else appear on that matter? The record should indicate no response. The record should further indicate this case was scheduled to be heard at 3 p.m. today on the plaintiff's motion to quiet title. It's now 3:03 p.m. by the court's clock. The defendant has failed to appear. What brings us into court today is that back on December 28th, 2020, the plaintiff, Donna Cyphers, filed a complaint to quiet title. On May 14 or May of 2021, the court issued an order for alternate service by publication. And then subsequently on May 19, issued an amended order for alternate service by publication. Apparently, service was effectuated by publication. Nevertheless, the defendant never filed an answer to the motion for quiet title, which prompted the plaintiff to seek entry of a default. And a hearing was scheduled today on the motion for entry of an order to quiet title. It was scheduled to be heard at 2 p.m. today. I'm sorry, it was scheduled to be heard at 3 p.m. today. It's now 3:05 p.m. by the court's clock. No one has appeared, nor has anyone filed an answer to the plaintiff's motion to quiet title. How did you want to proceed, Mr. Post?
Your Honor, I believe the court should have a proposed order to quiet title in front of them for signature. As you stated, service was properly effectuated through publication. No answer was given and a default was entered. You know, these are going to be, I don't exactly want to call this an interesting case, but I think this court is going to get more and more of these if they haven't already. Because really what we're quieting title, the main thing that we're asking to quiet title on is the manufactured home. The title to the manufactured home was in the Goff's name with a lien of Greenpoint Credit Corporation. And I've heard that the Secretary of State has changed their policy about 6 months to 12 months ago, and they now require court orders. And so I've gone from never quieting title manufactured home to doing, I have half a dozen currently just getting processed. And so really the main point of this is to have a court order for the Secretary of State to issue in Donna Cyphers' name regarding the manufactured home. All proper service was done, everything was done, and we ask that you sign the proposed order to quiet title.
Thank you, Mr. Post. The court has reviewed the proposed order to quiet title consisting of 2 pages. It's now 3:08 p.m. by the court's clock. No one has appeared on behalf of the defendants, Kenneth Goff and Dolores Goff, or Greenpoint Credit Corporation, nor has any written answer been filed to the motion to quiet title. Accordingly, the court has signed the order to quiet title that the plaintiff's attorney prepared and submitted to the court, to which he alluded a moment ago. Thank you, Mr. Post. And we'll be in recess then.
Thank you.